Dame Sarah.
Please call me Sarah. Don't call me Dame. This is, I'm not even used to it myself, but it all seems completely unnecessary.
But you deserve the honor, so at least I can do it once at the beginning.
We're amongst friends. So
before you joined, I was told off that I wear a tie, but I thought I have to do this in style. So
this is funny, isn't it? The rules about how one dresses for Zoom meetings are perhaps even more difficult than in person. So if I'm doing judging, then of course I dress as if not quite as if I was in court, because we don't wear gowns, but
okay.
I certainly dress formally.
Yes.
But I noticed that the other meetings where I would normally, wear a jacket, people are wearing jumpers, including the chairman. So I follow suit.
Yeah, normally I don't wear a tie. But I thought how do you say, I have to.
Oh, I'm impressed. I'm suitably impressed.
We have about half of the people here now. There are about 25 people who registered, and we have about half of the people here. Okay. So what I suggest is, like, we can do small talk for until 6:15, and then we will start a formal discussion with you. Lady Sarah, I think what I should do is I should introduce you to Professor Kinami. Hello?
I'm still here.
Hi.
Yes.
Professor Kinami? Hello. Can I introduce you to Dame Sarah Worthington, Sarah? And, we will, because we are Trinity in Japan, and at least some of us are in Japan, I thought we'll cover equity in Japan. And so I looked for who would be the best person to contribute the Japanese viewpoint. So Professor Kinami is professor of law at the University of Kyoto. And he is also teaching at the University of Michigan, Japanese law in University of Michigan. And so I thought he would be a very good person to bring in the Japanese viewpoint on equity.
Professor Kinami, I'm delighted to meet you. I really am.
Me too.
And also delighted to have an expert in Japanese law to fill in all the gaps that I couldn't possibly, I wouldn't have even commented on Japanese law. I would have just tried to talk to you about what English law might do in equivalent contexts, and then leave it to some of the experts to make the comparison. So thank you so much for being that expert.
My pleasure.
Professor Kinami also studied your book on equity, you know?
Did he?
I bought the first edition long ago when it was published.
Oh, really? That's amazing. The second edition.
I didn't buy the second edition, unfortunately. But
the second edition is really the same text, but with a few more few footnotes because people commented we need some cases. And at the end of each chapter, just a list of readings. So not really, the substance is no different.
I bought the second edition. I should also introduce.
I'll wait for my royalties to go up dramatically.
I bought your company law books also, but they are like 2,000 pages, so I couldn't manage to finish them.
Oh, well, you would have embarrassed me if you'd said you'd read them all. So
no, I should, Sarah, I should also introduce you to Kaori Ungara or Kaori Inui. And she's not Trinity affiliated, but her husband studied at Trinity. And Kaori is a Japanese lawyer, and she worked for some time in the Japanese foreign ministry. And she worked with the prime minister when he was taking these decisions on the Hansen's disease, which I mentioned. So she may know something about Prime Minister Koizumi's contributions on thinking there.
Which would be interesting. I found your comments on that very interesting. So on my screen,
yes.
Oh, so Kaori Ungara. Yes, I can see you with an impressive bookshelf behind you.
Thank you. It's great honor to be able to talk to you. It's amazing. And well, I haven't studied any Anglo-American law, so I haven't been practicing for a long time. So I am rather amateur here, but I am very interested and keen to learn from your perspective.
And likewise from yours. I think, isn't it interesting how often the fact that there are differences between two systems really teaches you something about your own system. So I can remember one of the, this is now a couple of years ago, but I got an invitation to go to Barcelona to give a paper on what civilian lawyers can learn about, well, these European civilian lawyers can learn about property law from English lawyers. And I thought, Barcelona, I'm going. I can do this. I can definitely do this. I'd only been to Barcelona once before, but quite a while ago. So off I went. But it meant that I had to really think about the difference between how the two types of jurisdictions think about property. And it ended up, I mean, that impetus ended up with me writing something that I think is probably one of the more important things I've written on English property law. So I like these kinds of conversations. They're good. They're good mental challenges. So I appreciate you coming. Yeah.
Thank you. Thank you.
I should also, Sarah, I should introduce you Peter Kilner, who is our big lawyer here in Tokyo. Peter, and he helped me. He was the chief of the Clifford Chance office in Tokyo and also in Hong Kong, and he helped me a lot with the preparation. So this 2-page document which we sent to you for preparing today, Peter, it's really Peter and myself who made this for you.
Very nice.
I don't know if to say thank you to him or whether to think that I am now the victim of these this list of interrogation questions. But
it's not an interrogation. I think they call these interviews, no?
Well, it seems to me that, I mean, you're all doing this on a Friday evening. It's a conversation.
Yes.
It's not a lecture or certainly not an interrogation.
You know, usually we do this at dinner in a restaurant here in Tokyo. And I hope that you will sometime find the time to join us here in person. But with the virus situation, we switched it to online. And today is really the first time we have it 100% online because they shut the restaurants so the timing wouldn't work. So we do it 100% online.
Well, I regret that I'm missing out on having dinner with you all. It is one of the things that we realize now, especially since we can't do it, that we most miss, isn't it? That, you know, the chats in the margins, we can do these sorts of things quite well. I mean, we're very lucky that we have Zoom and Teams and all that kind of thing. I'd be lost without them. But it's the chats in the margin that I really miss, you know, what you say over coffee and dinner and lunch and meeting people in the corridor. So let's see if we can get that. You know, we're having a conversation and let's see if we can replicate some of it without dinner, sadly without dinner.
So, but on the other hand, you know, we have people here, 2 people from Hong Kong, and we have quite a number of people from UK. We have maybe 5 people here. We have 1 person from China, 1 Trinity man from China, and 2 from Hong Kong, and maybe 5 or so here from Tokyo. Sarah, I should also introduce you to Rabea Brauer. And Frau Brauer, she's, you know, in Germany, there's an organization called Konrad Adenauer Stiftung. And Konrad Adenauer Stiftung was actually founded, I think, by the British Secret Service in Germany after the Second World War to help Germany to re-establish democracy. So initially, in the first years, Konrad Adenauer Stiftung had the job of, you know, teaching democracy in Germany, how to do democracy. But today it's a very big government-funded think tank, which does all sorts of things all over the world. You know, they do development work, they do defense coordination and policy coordination, and they do many, many things. And they study different areas of life, And it's a very, very interesting organization. Before I came as a PhD student to Trinity, I was studying in Germany, my first degree, and I had a scholarship from Konrad Adenauer Stiftung. And Frau Brauer is representing Konrad Adenauer Stiftung here in the Tokyo now. She's chief of the Tokyo office, and she's organizing very, very interesting programs here. And I won the most recent one I was invited to was at the Embassy of Hungary, and it was about Brexit, which I will try to avoid tonight because it's so kind of it's so divisive. People have so strong opinions in all sorts of directions, so it's better to leave this alone, I think. So, Frau Brauer.
Yeah. Good evening. It's a pleasure to meet you. Certainly is. I said that already. I don't have a legal background. Nonetheless, I am with an organization that has a globe-spanning rule of law program, which here we go. Our Asia rule of law program sits in Singapore, and we have on each continent one, because rule of law is apparently, if your mission is democracy and freedom and justice, they are of course in order. And we're working with the judges here in the region. We now reach out to the Supreme Court in Japan, but unfortunately they're not part of any association. Japan likes to stay away from things. And one of our main subjects is, of course, promoting women into judicial positions. So yes. This is one of the initiatives, and this is why I'm happy to join. And I heard that Gerhard has already passed on to you that question that I would have had. So how can we pump up the numbers? Of course, it's a tragic picture in all of the areas, but especially in the judiciary here in Asia, we see a lot of injustice done because the judges are male and the laws are sort of made by males, and it's a very sad situation, and it's well, it hasn't changed much over time. Yes. But also in Europe, we have the same, promoting women into judicial positions. The figures are better, of course, but they're nowhere near equal. I have done a little bit of research, not just because of you, but because we have that subject here in the region. And yeah, we have to be a bit embarrassed about this.
Yeah. Well, you know that it's the same in the UK as well. And it's the same at every court level. And indeed, senior partners, heads of chambers, so yes. All the way down the legal profession, not just the judiciary. So can we make sure we get to that issue? I mean, I don't have, here's what we should do to solve it. I certainly don't, but I would be quite interested in exchanging views about what could be done. So.
Yes, yeah, it comes down to policies and decisions having to be made by parliaments, by the lawmakers at the end, who mostly are male-dominated parliaments. Yes. So here we go again, that the necessities is forgotten or not promoted. Yeah, yes. But I don't want to intrude with that subject because you have so many other important issues to talk about tonight.
No, but some of the, so Gerhard and Peter had put on my list of questions, issues about corporate governance, and some of the ways that's dealt with plays across, I think, into equality and diversity issues and how they might be attended to. So you were saying, well, it will take legislation, and well, we should think carefully about whether it should take legislation. And I say that, for example, I'm, as you probably know, because I saw what Gerhard sent around about me and I thought, oh, heavens above. But I'm one of the fellows at the British Academy. And that, again, is an organization that has far more women, far more men than women. But at one stage, there was a proposal that the next year's election should be all women. And so in the law section, we met to discuss this proposal. All the men voted in favor, and all the women voted against. And they voted against on the basis that none of us would have wanted to be the woman that was elected in the year that was all women. And it, you know, so there's that, how did I get there, and will I feel as though my position is compromised because there was a rule that said, you know, 2021 was all women and she's one of them. So I think there are perhaps more subtle ways of going about it that eliminates that. But anyway, let's talk about it in that context.
If you don't mind, shall we start kind of the formal?
We sort of started, didn't we? But yes.
And if there's time, I think what we were thinking was maybe 30, 40 minutes or so, the formal part. And then afterwards we can have conversation again.
Yes.
That's okay?
Yeah, no, that sounds good. And so if I mean, you gave me quite a long list of things we might talk about, but, you know, when we get to the timing, let's just pause and other things can come up in questions. You know, there's no need to cover particular issues.
I mean, normally we have that over dinner and it's totally relaxed and with wine. And so maybe to get started, maybe what I want to ask you is first is, you were a scientist first, and then you switched from science to becoming one of the highest legal professionals. And you write in your interview, you say in your interview for the British Academy, you say that you are an equity lawyer to your heart and bone. And so that's a very interesting path. So maybe you can explain, you know, what brings you from a scientist to being an equity lawyer in your bones and heart, and what does that actually mean to be an equity lawyer in your heart and bones? Is that a good way to start?
It is a good way to start, and I mean, perhaps it's a good way, even though I haven't said anything about what equity is, but it makes me go back a number of steps. So at school, I had a very broad set of disciplines that I studied right to the end. So not at all like A levels in the UK. I was in Australia, and I would be a really strong advocate for having an education system where that happens. So our children all did the international bac because it does that kind of program. But I was also one of the kids that was good at maths and science, and I was of the generation where if you were good at that, then that was the natural direction that you went in. And I can't say I gave it that much thought about whether I'd go in a non-science direction. I thought a lot about whether I'd be a doctor or a researcher or you know, X, Y, or Z on the science side, but I didn't give any thought to all the other options. So I went from this very broad schools process to my first year at university, where two things happened. I did 2 lots of maths and physics and chemistry, so very science-based. So I didn't have the breadth. But the other problem for me was that the different states in Australia have different education systems, and I changed states and I'd done everything. So my first year at university remains intellectually the most, for what I was taught, the most disappointing year of my life. But perhaps that was a good thing, because I spent the year talking to all sorts of people. And I discovered these lawyers. And I thought, wow, that is a pretty interesting area of work. And then what you see is how long it took me to change. And that perhaps had more to do with being too young rather than not knowing, even at that very early stage, that that was probably my preferred direction. So I changed, I think, not because, you know, I worked for a while on melanoma research, and 2 members of my family have died afterwards of melanoma. So there's a part of me that thinks, well, that would have been a more important discovery to make some progress there. But I didn't. I went in the other direction, and I've loved it from the beginning. Right from being an undergraduate, I just felt as though I was in the right place where you're doing logic, So, you know, being very rigorous was important, and that's a scientific bent. Thinking about how the world works in a way that's quite physical so that you can see people, and it's got the difficulties that are associated with rules for people. I mean, we don't operate like widgets. I really liked that. And being required to write. You know, in my dreams, in my next life, I'll be a novelist, but, you know, and I liked those three things, that it was logic, that it was rules about people, and that it required me to think carefully and write clearly. And as an undergraduate, as I said, I liked everything from the beginning, but probably I was in about third year when we first hit equity. And the thing that's different about equity is in the English common law system, it deals with difficult problems. I mean, that was its history, that the general rule doesn't seem fair in a particular context. So equity invents another rule to operate in a distinctive set of circumstances. And how I first hit it was with fiduciaries. And we've all heard about, you know, directors of companies have to behave in a fiduciary manner. So these were the people that I came across. And I think why I liked it was that here you had a problem that didn't have the obvious solution that the good person wins and the bad person loses, and the bad person pays damages for the harm they've caused. You had a different problem. You had the moral hazard of the fiduciaries acting in their own interest, and we had to think of a different way of dealing with it, because you couldn't say you'd caused harm. That wasn't the problem. They often hadn't caused harm. They'd taken a benefit themselves that they shouldn't have taken. So equity classified that group, that was the distinctive group we were talking about, and imposed what at that stage was a really novel remedy of saying, no, you don't have to pay damages for the harm caused. You have to give up the benefits that you've taken. And now it seems, you know, so blindingly obvious. What else would you do? But at the time, and it took quite a lot of years, and perhaps we're still doing some work on classifying the group, it was smart. And so, you know, that kind of intervention struck me as really clever. And equity does the same in property. So it's the clever side of taking a problem and thinking more laterally about the best way of solving it that I really liked. And since equity deals with difficult problems, you might say all the difficult parts of law are equity in the English system. And I like the difficult parts of law. So that's why I'm an equity lawyer.
And so you say you're an equity lawyer by heart. So what you all set up to now is pretty rational, and heart is kind of emotional. So what is the emotional side of equity?
Gerhard, when you put it like that, it's the emotional side of equity isn't for me any different than the emotional side of law, because you know, I don't hold to the view that the common law is one sort of law that's, you know, cold and hard and calculating and has rough rules, and equity is the soft, gentle, fair, just, discretionary way of approaching things. I think we all live in our different jurisdictions in the kind of world where we expect to be governed by laws that are fair and just. And that doesn't mean that they're gentle. It doesn't mean that people who've done particular wrongs won't be punished. You know, we put people in prison and we, you know, do these various things, but we expect that the rules themselves will have an inherent quality of fairness, in the sense that whichever side you were on, you know, the wrongdoer or the victim, these were the kind of rules that you might expect your society to operate by. So fair rules. And then for me, the rule of law part of it is that there's a respect for the institution that those rules will actually be applied equally, no matter who's before the court. So my emotional commitment is probably more to that methodology in dealing with social problems. I mean, there are all sorts of ways which social differences can be dealt with, and the law at its best is quite a clever system for enabling people to live together, where we don't all know each other and just trust that each other will do the right thing by us as we might in a family. So the emotional side for me is at that level. Why emotionally an equity lawyer? That's just, I mean, it's a bit like saying, why are you emotionally, to me, it's a bit like saying, why are you emotionally committed to the sort of maths you study? Well, intellectually, I just love it. And so there's that, there's that side of it. And perhaps I love it because partly because it's difficult. I mean, equity often deals with situations where, let me think of a common example. So say in insolvency, someone becomes insolvent and all the creditors are going to have to share the losses. So we have to work out how innocent parties will bear the hit. So there isn't a goodie and a baddie where it's pretty obvious that the law should, you know, do something to the baddie to make them try and right the wrong. That kind of law is simpler to set out the basic rule. I know it's terribly complicated to do all the nuances, but it's simpler to set out the basic rule. In insolvency, it's not simpler to set out the basic rule. And when you're going to make innocent people lose and lose differentially, you have to pick a rule that's going to be fair in distributing the losses, and then you have to hold to it really rigorously, because if there's any, this time we think this poor creditor should get a bit more, that's, for me, against the rule of law. I mean, we should at least know what will be happening to us. And so a lot of my work is in property law, personal property rather than land. And a lot of that is for exactly that reason, that we need to be clear why we have property law rules, because the consequences when you have to determine priorities amongst innocent parties can be quite tense. So often the outcome doesn't seem fair. You know, someone steals my bicycle and sells it to some poor innocent party who pays good money for it. As between me and the poor innocent party, who wins? So we have to decide on a rule and then keep applying it, you know. And so I like the intellectual toughness of it. And I've rambled on about that, but I guess universities are full of people who like the intellectual challenge. And so when they say they love something, it's the sort of intellectual challenge that they find endlessly engaging. And I mean, look how many years I've been doing this. I still have that same fiery passion for the stuff I'm dealing with that I had right at the beginning. Someone once said to me when I first became an academic, you know, it'll wear off. Well, I think I'd change jobs if it wore off, but it hasn't. So.
Well, you have a number of jobs, so you can spend a little more on this job and a little more on that job.
That's true. And I do like that flexibility in academia, that you can do a number of things and it is all counted as part of your job. I probably wouldn't be very good at turning up doing one thing all the time, but a few people in, you know, serious jobs do one thing all the time. They all have variety.
Sure. I mean, what you're describing about equity sounds, of course, as if there's a need for equity in all societies. So since I'm here in Tokyo now, and we have quite a few people here from Japan, you know, the interesting question would be to look at, you know, what is the impact of your thoughts of equity in Japan? And so I have asked Professor Kinami here, who very kindly joined us. And as he told you before, he has read your book in the first edition a long time ago. So you can see that your work has impact in Kyoto, and equity has impact in Kyoto. So in preparing this, in my time in Japan, I'm not a lawyer and I'm a physicist, so my work is not in law, but I'm always a little bit interested. And one of the things I have been very struck with is this situation here in Japan where Prime Minister Koizumi, about I think 20 years ago, he was overriding the normal process of justice, where there was a case of so-called Hansen's disease, which is a very serious disease. And by law, the Japanese government was creating laws, and then not the government, the parliament passed laws, and then as a function of these laws, the Minister of Health segregated infected people into almost like prisons or worse than prisons. And these people were isolated for a long time, even when the disease could already be healed with medical methods. And so the state was very slow in then taking back these very strict laws. And then the patients were suing the government for compensation for what they felt their personal rights were infringed. And the government was taking these lawsuits for a very long time. And there were, so the patients who had suffered, or they felt, they had suffered, and they were claiming for compensation and, remedies. And but the government was not letting loose, they were just these lawsuits were going on for, I don't know, 20 years, and the patients were already dying. And so then Prime Minister Koizumi stepped in, and he kind of cut this Gordian knot, and he took a decision, which reminded me of your discussions in your book about the history of equity, where where people who felt they could not get remedies in the normal common law, then they could go to the king and ask for a solution there. So maybe that's a starting point to look at equity in Japan. Maybe we could ask Professor Kinami to give some input here.
Thank you for calling on me, but I don't understand why what you describe has anything to do with equity at all.
Oh, okay.
But that is the problem in that situation, was the statutory of limitation. Statutory limitation.
Yes.
Their claim was barred by the statute
of limitation.
Yes.
But Prime Minister Koizumi, he overrode the statute of limitations.
He has, what he did, I don't think nothing
to do with
anything to do with law at all. It's a political decision.
Yeah. But that is very interesting.
What he did is to make sure that the victim will be compensated. So by changing law or government position on the litigation.
Okay. But I'm not a lawyer at all, so but to me it sounds as if, normally laws would be changed by the parliament, not by the prime minister.
But he can order the minister to change the position in litigation. Or he can say that let enact a law that will enable the victim to sue in the court. Or he can order to create a compensatory scheme. In outside the government responsibility scheme.
So maybe that's a dead end to look at, maybe that case is not a good example when we want to discuss equity in Japan.
Gerhard, it's not, so I won't comment on that case, but it's not a bad example to think about how things happen in some ways. So you started off your description saying, you know, when I described early systems of law, I said that very often you start off with a crude general rule, if I can, but by that I just mean, you know, a basic rule like thou shalt not kill. And over time, it gets to be more refined and more sophisticated and more developed. And we decide that, well, sometimes you can kill. You can kill where it's a just war, you can kill in self-defense, etc., etc. So the rule develops from something that, you know, in its general terms, it is fine as a, you know, this is, we don't want people to kill. So, but we don't want everyone who does kill in every single circumstance to suffer the same consequences.
Okay.
But for all societies, that transition from a general rule that doesn't quite work all the time to a more sophisticated rule has to happen somehow, doesn't it?
Yeah.
And so in the English system, and I think in a lot of, you know, tribal systems in Africa and that kind of thing, you have your general rule, and then you have an appeal for, please grant me some freedom from that rule to whoever the ruler is. A bit like, you know, the departing president in the US issuing, you know, well, allowing some people to go free. Well, we don't have that process anymore, but very often that was the initial process. And then slowly it's embedded into the law. So I don't think that part of getting, and in England it was done through the Chancellor and the Chancery Court, so the equity judges. But I don't think that transition is anything odd. You know, every society that's developed now has more sophisticated laws than it used to have a couple of hundred years ago. But what is odd in England was the dualism, you know, that we maintained for such a long time, two places to do this. And most other jurisdictions just said the law is that if you kill someone, I mean, that's not a very good example for me because this didn't happen in equity, but, you know, if you kill someone, the consequences are X, Y, and Z, and that's the law. We for a long time said, well, the contract's binding at common law, but voidable in equity. Well, that's a silly thing to say. The person just wants to know it's voidable. So that's one aspect of what you're saying. But the other side of it is perhaps more interesting, and something that I think, for example, that the Americans understand less about us than we might expect, is that in America, you have a constitution, and the laws that are made by the legislature have to be in accordance with the Constitution. So in a sense, the highest power is the Constitution, and the judges can decide that the laws are not in accord with the Constitution. Whereas in the UK, Parliament reigns. And so, you know, if Parliament doesn't like what the judges have decided or doesn't like the previous law, then Parliament can change the law. And the post-Brexit, one of the post-Brexit tensions is what will happen to the Human Rights Act. Now, I think it would be politically unwise to suggest that, you know, this should just be written off the books. But it is an example of what, while we were in Europe, had a kind of higher level of making sure the English laws were in accord with the Human Rights Act. Well, we'd enacted the Human Rights Act. And now where it's just a law and it could be written off the books by Parliament. So Parliament is sovereign. The judges could make a common law decision, and if Parliament doesn't like it, it could enact legislation that changes the outcome. And indeed it has done that very often in much more technical areas where, you know, you've decided that, for example, you know, one of the things I'm familiar with is certain costs on liquidation will be paid in this order of priority according to common law rules. Sorry, we don't like that. We're changing the legislation and we're going to have a different rule. so the difference between us and the United States and the dominance of the Constitution and the respect that's given to that, and in the UK, the dominance of Parliament, is says something very special about the difference between the two lots of laws and how people operate. And so, you know, our Prime Minister couldn't have done what it sounded like the Japanese Prime Minister had done, but Parliament could have done it.
Oh, okay. Yeah.
So not the government, but Parliament. So both sides voting to change the legislation.
May I say something?
Yes.
In Japan, the Prime Minister is the head of the ruling political party, and the ruling political party has the majority in the Diet. So if the Prime Minister have a political capital and strong will, he can or she can declare a certain policy and have them accepted by the ruling political party and enactment of the policy he or she proposed. And he is also the head of the cabinet. So he can order the cabinet ministers to follow his direction. And civil servant will follow. If Prime Minister have a strong will and which is supported by political capital, he can do things like that. But he cannot order the Supreme Court to do justice.
So in the UK, it is exactly as you describe it. You know, the Prime Minister is the leader of the winning political party and can kick people off cabinet if they don't vote in Parliament in the way that he wants them to vote. But he doesn't always, or she doesn't always, get her own way in Parliament, because members of Parliament are keen to be re-elected again, and they do have an ear to the ground about what the public wants. And so there are various instances where things that the Prime Minister has wanted to go through Parliament have been unsuccessful. And I don't know about Japan, but well, maybe the politicians are more compliant, but you know, quite a lot of things will go through for exactly the reasons you say. This was party politics. This is party policy, I mean, and this was what we were, the platform on which we were elected. But look at what happened with Brexit votes, and I think the same might happen with tax, and look what might happen with social security provision and that kind of thing, where there will be a tension amongst the MPs, the members of Parliament, about whether to follow the Prime Minister if he's going to be tough, or whether to favour their electorate and try and get something slightly softer that the electorate might like better and might cause them to be re-elected again when the elections come.
So the situation Gerhard described in compensation of the victim is not the major, was not the major on the one of the major agenda of the political party. So he could do that.
Yes, yes.
But Professor Kinami, one thing which was interesting in what you said is you mentioned political capital. So that looks as if you have in this space, you have the parliament which has power, you have the prime minister which has power, you have the ministry, the minister who doesn't have so much power, he has to do what the prime minister says. And then you have a kind of how do you say, a elephant in the room, which is the political capital. So can you say something about the force of the political capital in the legal system? It's very interesting you mentioned that.
It is about how to change the political, change the legal rules. Or if you, as Sarah mentioned, you have to get your party MPs understand your position. Those MPs are more or less concerned about coming back to the diet.
That's the same what Sarah said for UK.
Yeah, so vector should be in the same direction for the Prime Minister and the member of the party. But in case of the compensation, I wonder how many members of Diet who belongs to the ruling party cares about that. It may be the principle maintained by the bureaucracy in the Ministry of Welfare.
Okay.
And incidentally, Prime Minister Koizumi has a strong grip on the bureaucracy in the Ministry of Welfare.
Maybe Kaori-san, maybe you like to comment on this.
Right. Yeah, so the thing is that the Prime Minister Koizumi's decision as such was political, because the local court in Kumamoto already had that decision or the judgment that the victims are supposed to be compensated. And what Mr. Koizumi at the time decided is not to appeal, which is within the existing sort of judicial and legal system. And I think if I understood correctly, the notion equity would be like how to achieve justice and equity, in particular, as again Sarah said, in a difficult case. And this case was already decided by the Kumamoto judges. And it could have been brought to all the way up to the Supreme Court, and Supreme Court could have made the same decision, but it would have very much prolonged.
It would have taken 5 years or 10 years, and the victims.
Yeah, and by that time, everyone would have been dead. And it was a political decision. We have to save or compensate these people. And the thing in Japan is somewhere in terms of equity, what is interesting is that Japanese court also has this right or the capacity or authority to judge the certain law is illegal, unconstitutional. And what comes to my mind as interesting is our criminal code, criminal law used to have this special case of if you killed your parents or grandparents who are sort of familiarly above you, it would have had severe punishment, which wouldn't have the court to allow suspension of the imprisonment. And there is this case, a daughter, it's a really gruesome case, daughter who had been raped by her own father for years and years, killed her father. And the court judged that this provision of what we call sonzokusatsu, is this senior murder, is unconstitutional because it is against the equality of the human beings that is in the Constitution. So the court said this provision is void and she cannot be judged under this provision. So she was able to get suspension of the sentence. So that, I think, is somewhat of the equivalent, could be, of the notion equity, how to accommodate this special situation into the difficult cases. So I think in Japanese case, it is achieved by judges, and it works as such that in Japan, it's civil law system basically. So the judges are not bound by the precedent. It de facto binds if you're a young judge and the Supreme Court has already made certain decision. It will be very, very, very difficult for a young judge to say, nah, I'll write different thing. But theoretically, if this first-year judge believes that this is not right, sincerely, I believe in light of statutory law and this situation, this has to be the judgment. He or she can make different judgment, different from the precedent. So I think the notion equity equivalent works in Japan in such a way based on the judgment of individual judges.
Yes.
That's how I understand.
It's a nice example. I like that.
And may I say something about what Kaori-san said? She mentioned the Kumamoto district decision, and which said that the victim has a valid claim, and the government position is the claim has been barred by the statute of limitation. But the three-judge panel of the Kumamoto court creatively interpreted the provision in the statute of limitation. So it's a kind of equitable interpretation of the statute to have justice done. The judges reach that interpretation of the relevant statute.
Okay. Sarah, do you mind if we go to the next point? Corporate governance, if you like.
I'm in your hands. I'm in your hands.
If you like, I'm sorry, we've taken quite a bit of time on these interesting Japanese cases. So the next point is really that, a big part of your work is on corporate law. And I have your very big books on corporate law and corporate governance and what the duties of directors are. And there's a big change in what corporate governance means and how also the role of directors and the obligations are seen.
Yes, this is a really interesting area for lawyers, isn't it? Because the problem with corporate governance is, I suppose, we realize how much power large corporations have. So, the statistic that used to be billed maybe even a decade or more ago was that, of the 100 largest economic organizations, more than 50 of them were companies rather than countries. And I'm sure it's even higher now. So there's this sense that they have a lot of power and influence, and yet not very many constraints other than minimum legal rules. Below this, you'll be doing something wrong. And that minimum standard is what lawyers are very good at. We have, rules about criminal law, we have rules about, torts and civil wrongs and that kind of thing, but they set minimum standards. And there are plenty of those kinds of rules in company law. So, lots of directors' duties are setting minimum standards. But the real drive over the last, it would now be at least 30 years, maybe even longer, has been a push that these companies don't just observe the minimum standard, but we actually want them to behave better. Now, that's something that lawyers are less good at, because how do you set a law, a requirement that companies behave at some aspirational level? Because in that gap between the minimum and the aspirational, you don't really want to say, well, you've committed a legal wrong because you didn't meet the aspiration. I know in some areas we do move the levels up. So if you think of pollution controls and all those sorts of things, well, our standards have got higher and higher, but that just means that the baseline level has got higher. But we wanted something more than that. And I think lawyers at the beginning were unsure how they slotted in. So the first approach was probably just disclosure. Companies will have to disclose, you know, sunlight's the best disinfectant sort of thing. And so you compel disclosure, but nothing else. You just leave it then to the market to make its assessment of what things are going on. And, you know, very often you can get a bigger reaction ringing up the newspaper or putting things on the social media than you can going to any judge anywhere in any country. But the big legal move came with codes of corporate governance that were comply or explain, and they were best practice codes that didn't look at outcome at all. They weren't setting standards of what had to be achieved. They were just giving best practice for process, governance processes. So, you know, you'll have a board that has these kinds of elements in it, and you'll have committees that do these kinds of jobs, and you'll have meetings that achieve these kind, you know, designed to adopt this kind of process. So all process. And not a law that you had to have that process, just tell us whether you do or don't, having set up this best process. With the thought being that if you have better process, then the outcomes are likely to be better. And so, you know, the corporate governance code that the UK currently has is of that version, but directed at governance, not directed at anything else. So the company's own governance and, you know, stakeholder engagement is a similar thing directed at engagement. Whereas I think what we're now seeing is a move where it's not just internal governance we're worried about and the sorts of moral hazards that happen in that space. We want, you know, environmental protection and social protection and all those kinds of things. And it's a bit less hard to see how, it's a bit harder to see how to achieve that. So disclosure kicks in again, you know, disclose how many women you have on your board, disclose what your environmental impact is, disclose, you know, there's that mechanism. And that can be pretty effective because especially if you benchmark against other people in your industry, it can say some very powerful things about your relative standing. But it's not a law that says you must achieve these particular ends. So perhaps I should pause there, but as a lawyer, I find this interesting that we're quite good at setting baseline minimum standards. And I think we're often very good at process. You know, think of probably everyone who's in this room will know, you know, how many committees where people will say, oh, let's have a lawyer. And very often it's for process reasons. It's not because they have a particular knowledge about an area, but we're quite good about thinking about how to deliver a decision. So process, but whether it's made a huge amount of difference to what we get out of our companies, I'm not sure. You know, I wonder if a lot of it's just been delivered by disclosure. So that's a very waffly answer, Gerhard, but it's a space that lawyers have a part to play in, but they certainly aren't the last word in driving outcomes that we all seem to want.
In funny ways, sorry, Adrian Knight speaking from London. I think this is the area which the professional service firms have filled the gap. We've essentially been giving the advice on the law. The governance comes in to sort of try and improve standards and put disclosure. And then, as you say, we have this corporate governance code, which is enacted by the Financial Reporting Council. And you have section 1721 disclosures in your report and accounts. And that is a process item. And I think it's something where it's not so much a legal ability to say whether it's tick in the box. It's very much the big four accounting firms have moved in here. And I think it's an interesting challenge to how the lawyers can, in a sense, claw back some of that work, because I think there's so much importance now the market attaches to the disclosure and greater transparency and all the items we've been talking about the last 10 minutes. And I think that is the fundamental driver for investment decisions. But it's almost as if the lawyers have sort of let that part of business go away from them.
That's an interesting comment, I think, because don't you think the accounting rules have got so specific and technical that very often you can work around them, I suppose, to look as though you're achieving certain ends without actually, I don't know, necessarily being, doing the things that one would want you to do. So technical compliance might not meet what we need, and yet just qualitative assertion that, we're doing all wonderful things in relation to all our broad stakeholders in the community, it is also not good enough. So it's the space in the middle that you would think lawyers be quite good at capturing. But
I fear it's an area where historically I think lawyers have, I've been practicing law for 30 years in London, and so much work has been left on the table for what used to be called accountant firms, now called professional service firms, investment banks. I was talking to somebody in HSBC last week and how they're using the cloud and blockchain to sort of really improve access to institutional clients, to institutional placings. There's a whole panoply of legal transactions going ahead literally in the cloud of investment banks, and very little conventional lawyer expertise in it. Yes, in-house lawyers in banks, but the practice of law is fundamentally changed, and it's very much driven by technology, I think, as well. I think that's a huge change over the last 10, 20 years, and how you can get an appropriate level of disclosure, transparency in a cloud through technology. And it is the digital innovation arm of the professional service firms that can really help corporates tick the box that they are playing to the rules, even not a breach of a rule which has a legal consequence. And they also supply a legal and regulatory arm as well to give a sort of a one-stop shop. And it's quite an interesting dynamic happening in the legal profession, I think.
Adrian, I mean, there are a number of aspects to that. One is, capture of the advice and system setting that might be done by the professional firms. But the other, when you're talking about the cloud, do you mean that in the sense that we're ending up with a bit of a black box of what's going on in that space? So it's
well, I think there's a bit of a black box to what I call the wider public. I mean, clearly there are people with lots of money, lots in Asia actually, lots of Chinese billionaires have clouds, and they can be accessed by the big professional banks, and securities can be transferred, cash can be transferred back, bitcoins, and it's an interesting area, and the general market doesn't see it, and the disclosure is very much a very private disclosure at a different level, literally, from what sort of the retail client is doing and looking at. And I thought it was very interesting how you were explaining how the company law, the corporate governance, and you made some really good points there. And I think that how the corporate governance has come on added to legal compliance, but then it's essentially what's the remedy? And it's sort of transparency is taken over from equity, really. It's essentially it's transparency, and people pay or don't pay depending on what they see disclosed. It comes down to sort of, well, I'll sell my shares, I'll buy those shares, and it's not so much the rule of law. It's the rule of disclosure and transparency,
and
which is quite equitable.
Well, in one sense. In another sense, I mean, we've seen so many political debates carried out where apparently there's disclosure of the various arguments, but it isn't proper disclosure at all, and it's certainly not intelligible to the people who are having to make decisions, or are making decisions on the basis of information they've been given. And
you've got the almost excess disclosure, so you hide in a lot of disclosure something which is quite important, and the average man or woman won't spot what's hiding in page 45. and there'll be a general disclosure of the first 2 pages, which look fine. I'll tick the box. You know, the
Yes.
Boris Johnson as well, we'll just read the first 2 pages. Oh, that's perfect. And hidden in page 48, there'll be something which really is completely against what the first page says. You know, that's what lawyers have been doing for years in a way, but in a sense, it's almost more criminal now that you rely on great disclosure and transparency as being the key to test whether or not something is right or wrong.
Yes,
Because you can hide things. I mean, look at the times when you decide to, on your mobile phone, do you want to accept cookies or not? And the guys that do the straight yes or no, I'll do the no. But then they're very helpful. People give you 50 pages and various email addresses of people to complain to. I just cancel. I just don't do that. Because it's overplaying the disclosure game, because you know you're not going to send an email to somebody in Hong Kong to try and avoid a disclosure in London. But a simple yes and no button, I'll go with that, and hopefully I've made the right decision.
But regarding disclosure, you know, one of the things I found interesting is, you know, I was board director here in Japan of a publicly listed company. So that was the first time I've ever been board director of a listed company. So I had to learn myself. So I was reading what, you know, whatever I could reach, which to learn what it means to be a board director. So one of the things I was reading was the Kay report by Professor Kay of Oxford. And I think as a function of this report, actually disclosure was reduced in that the duty to publish quarterly financial reports, I think in UK, was ended because of this report. So I think he recommended actually to reduce this financial disclosure.
I think that's sensible, because I think there's now been too much disclosure in report and accounts to comply with the Financial Reporting Council.
You know, so I was a board director for 4 years, you know, and I made an agenda, and I'm a pretty aggressive guy, you know, professionally. So I was pushing for a lot of change in the company. I mean, that's why they appointed me. I was the only foreigner, the only non-Japanese on that board. All the other 12 people on the board were all Japanese, and 2 of them were Japanese lawyers. So I learned a lot from them. But the lawyers, of course, have a very different perspective, because you know, I'm a physicist, so I was looking mainly at the business side. So I was looking at the different parts of the company, and then, for example, I compared one part of the company with a corresponding very similar US company, which was performing much, much better. So I looked into that, and I told them, you know, why is it that this US company is so much better than you guys are? You know, so we have to learn from this US company. And these Japanese guys, they had never heard about this US company, you know, and that's the kind of thing which is kind of outside lawyers kind of normal perspective. So Sarah, what do you think?
May I ask one question?
Yes, of course.
Yes. I have worked in the Secretariat of the OECD, Organization for Economic Cooperation and Development, as well as in the United Nations. I know that there have been lots of attempts to work on CSR, the corporate social responsibilities, and the United Nations have been working on Global Compact, dealing with environmental norms and anti-corruptions and labor laws. And I wonder whether those international efforts will have some sort of a political pressure on corporations, even without domestic laws. I mean, Gerhard, mind you, the Japanese companies big companies are very much aware of this OECD's CSR guidelines, and also they belong to the UN Global Compact. And so the corporate governance has been a very important element for any government. We have all the troubles with Toshiba and others. But without domestic laws, I wonder whether international efforts will have some bearing, or they have so little influence at the moment?
Sarah.
It's a tough question to answer very definitely. I think the fact that there are global rules, you know, even if they're just statements of ambition, are very, very important. So that's the first thing, because I think they set a mood and a tone that there's a lot of countries that subscribe to a particular approach to a problem, and that has advantages. It has advantages in all sorts of areas, but certainly has advantages in this area. Secondly, I think that since lots of these very big companies are operating internationally, it helps if each of the countries, no matter what their domestic base, you know, what their head office jurisdiction is, are subject to the same rules, because in many senses they're competing with each other. And if I'll give you a silly example, you know, if one country is particularly against bribery and another country is not, then when those companies compete in the same jurisdiction and one is competing because they're bribing their way to the deals and the other is not, that creates its own level of unfairness. So, you know, it's another reason to have the same rules. But I'm not sure that it works so well to say we're going to have an international corporate law rule. I just don't think we'd ever get to something that was more than really minimal standards, because there'd be too much national competition for claimed differences. So, I mean, say you take tax as perhaps a less controversial example. You know, we think that companies set up their structures, you know, their group structures in particular ways to minimize their tax. They're not behaving the slightest bit illegally. They're certainly behaving in their own interest, and we can complain publicly, you know, as in the public reaction to that kind of approach can be quite vociferous. You know, I think of what happened with Starbucks in the UK, when it seemed that they weren't, you know, they were paying next to no tax in the UK, notwithstanding that every corner seemed to have a Starbucks shop on it, and they wouldn't be the only ones. But we wouldn't ever, I don't think, get all countries taxing corporates at the same level to level the playing fields. It just wouldn't happen. And that really illustrates a tension where the companies are behaving legally. So it's not as if, you know, you're bribing someone or you're not. It's not that kind of moral difference in what the companies are doing. And yet the differences can have profound effects. So I do think this is a really tough area, because companies have so much influence. They employ so many people. They have so many customers. We depend so much on what they do. And we've seen, especially in the UK post-Brexit, you know, it's weeks post-Brexit, but we've seen some of the differences emerge that have an impact that, well, some people might say, we weren't told about this. I mean, the other people would say, well, we warned you, but it highlights legal differences.
Thank you. Thank you, Sarah.
Thank you. Sarah, do you mind maybe we can go to the next point, and that's your fascinating Cambridge Private Law Center. I've seen some of the YouTube, you have a very, very intensive YouTube program. So what is your, why did you set it up? And what do you want to achieve with a private law center long term?
You know, I was surprised you picked on this, because I think of it as such a little endeavor. And it has little ambitions in, you know, small really? Scale ambitions.
That's not what I would associate with you normally.
No, lots of people set up centers because they have a big project that they want to deliver. And, you know, I've been involved in those sorts of centers, and they're often very effective vehicles for delivering a particular outcome. So, you know, it could have been a science outcome, like we're going to find a vaccine for COVID. You know, you set up a center and you pull people in, and you can do all sorts of things with a bit of structure. And, you know, a house that can claim particular publicity and grants and all that kind of thing that is useful. But this wasn't like that. You know, I didn't have a plan for a legal output at all. I had started it really because I'm quite passionate about getting private lawyers who seem, private lawyers in academia are in the minority. There are lots and lots of, you know, EU lawyers and criminal lawyers and international lawyers and, you know, all the kinds of more sexy subjects. But private lawyers, I guess the attraction to practice are high. So private law academics at universities are smaller in number, and yet often intellectually fabulous colleagues. And I felt as though the group of private lawyers in Cambridge, the junior and mid-career people, you know, I had gone because I thought I could help. And so I had gone with an ambition for getting them to produce better work themselves and to be better known outside the institution and to have some fun. So almost everything we do is directed at that end. You know, let's discuss work in progress before it gets revealed to anyone, because that kind of discussion invariably makes your work better. Let's have outsiders to come in, partly to make your work better, but also so that we get better known. And, you know, people appreciate that there are some good private lawyers here who could help you do things, you know. So, you know, here are some talents that you might not have been aware of. And we've certainly had some fun. You know, we do, it's been great. You know, I feel as though I have really nice links with going a long way down in the faculty, whereas differently from, you know, science laboratories and places where, you know, all sorts of people work together. So my experience as a scientist, very brief though it was, in a laboratory was, you know, that from the youngest to the oldest, we're all around there all day. Yeah. It doesn't typically happen with academics who are doing their own private research by themselves, producing their article with them being the sole author. Yeah. So this was a vehicle for a bit of group dynamic. So very small ambitions, very, very small ambitions. Right. But
what are typical projects you're working on or questions you're approaching now?
Okay, so sometimes we do work on a project in the sense of producing an edited collection on an area of law. So we did an edited collection on commercial remedies where, you know, as it turns out, it covers almost every area of commercial remedies. But what we were doing was picking difficult issues in commercial remedies. And the way we structured...
Can you give us an example? Can you to visualize?
Well, you know, should we have a rule that makes a penalties clause in a contract?
You have this video where you gave a talk in
kind
Australia.
Of idea. Or should the remedy for unwinding a contract, you know, you and I enter into a contract that's void, so it's going to have to be unwound because we shouldn't have entered into it. Is that unwinding an unwinding that gives me a proprietary interest in what I handed over to you, or does it just give me a personal right to money, the money equivalent, which of course is crucial in insolvency because the property right. So you could almost go through every single area of remedies and pick a problematic issue. And we drew up a dream team list. You know, if this was the topic, then who would you ideally have to write on that? And there are 20 odd chapters in this book, and I think we got one person who couldn't write on it, and he was just overcommitted. But so that's a sort of bigger scale endeavor, but it's not it's not like finding a cure for cancer. It's attacking a particular parcel of legal issues that could best be done by a number of people rather than one person working their way through every issue. And we can work on it as a team. And so, you know, we did it quite seriously where we had drafts and we got outsiders to come in and discuss them with us, and we refined the drafts, and we, you know, kept on working like that and produced a book. And now you look at the book and you think, well, things have moved on a bit. It's, you know, not time for another one, that's for sure. But, you know, the world moves. Yes.
There's, if we can go to questions, there's maybe the first question I can pick is by Judge Witold Pavlak, who is he's a Trinity man who, oh my God, I just see an email here. He couldn't find the link. Just one second, I'll have to invite him again. He, just one second. He seems to have missed the link, so I have to send that to him again. Just one second. Witold Pavlak, he's a Trinity alumni, and he's judge at Wood Green Crown Court, and he spent so mainly criminal law. And when you put his name in Google, you'll find all these horrific cases he has judged. And where's his question? Yeah, yes. He gave us a talk here also at Trinity in Japan at our dinner meetings. But his question is the ancient maxim, necessitas legem non habet, necessity has no law, envisages a state of exception. How well do you think democracy has survived the global pandemic? So it's a good political question anyway. It's kind of the interaction between, there's another question which is also more or less a similar topic. So what do you think about this interaction between global pandemic and law, and like the Prime Minister giving directions which take force 2 hours later?
Can I just park the democracy bit for a minute, because I think democracy is about, well, for me, it's about something a bit different from the basic, you know, necessity has no law issue. On the necessity has no law, we can all, I think, see the impetus that, you know, in particularly in emergency situations, then we're going to put up with constraints on our rights that we wouldn't put up with in normal times, or we're going to allow that people would do things that we wouldn't normally permit them to do, or that we'd normally make them liable for doing. So, you know, if you're you know, you're operating on someone on the top of a mountain rather than in a well-equipped hospital, certain things that you do are going to be absolutely fine. And yet if you tried to do them in a hospital, you'd be struck off as a doctor. So there's that context idea that clearly has a major impact on what we will permit to happen. And you might say that COVID has enabled the government to make particular rules that constrain our liberty that we wouldn't put up with in normal times. Although you might note that quite a lot of what's happened in England has been guidance that we have all agreed with, not, you know, that most of us have complied with, rather than legal rules. But the no in it, necessity has no law, I don't think that we here, or probably you in Japan, would go that far. And, you know, the typical example that's given in this area is, will you torture people to extract information from them that could save you from a terrorist bomb? Answer, no. And yet, you know, we've all been asked that question, that, you know, the train's coming down the track and it can go left or right, and there's one person going to be killed left and, you know, 30 people right, but the one person is your child. Which way do you send the train? We understand the tension, but still we have this baseline that the kind of society we want to live in just doesn't do, so it just doesn't do certain things. So I think there's a limit to that. A necessity has no law.
Okay. So,
even though, if pushed, we might each individually find that line quite hard to stick to. Yeah.
there's maybe we can switch to the question we started discussing, I think, at the beginning about the numbers of women in decision-making positions, which includes, of course, the judiciary. But it's a much broader issue, which is extra super important, of course.
Yes. So I think it's very easy to say and to commit to the idea that if we have a more diverse decision-making body, whether it's the top of a company or judiciary or the top of a law firm or the top of a university, a more diverse viewpoint at that point of decision is likely to produce a better decision. But even just saying it like that makes you appreciate that it's the intellectual inputs that you're trying to seek diversity in, and we expect that those will come from different life experiences. So, you know, women will have slightly different input than men, and people with different social backgrounds will have different kind of input, and people of different national backgrounds will have different kinds of input. And so, you know, as appropriate, I think we would want the best decision making at the top of a, you know, in the top court or in any court or the top of an organization. But I don't think that we want a representative of the country group of people. So, you know, this is not like picking a jury to decide something when you're picking who should go on the Supreme Court. The Supreme Court has a particular job to do. And so along with this idea that you need diverse thinking, you also need particular skills, knowledge, skills, abilities that isn't evenly distributed across the population. So I think we have to hold those two things in tension and appreciate that we can't just, you know, add people randomly just to get a particular spectrum of what the top group, wherever we're talking about, looks like. And that tension is quite hard to hold to. So very often in discussions about whether we'll have, you know, more women on boards or more women in the judiciary, people will say not enough qualified people apply. Yeah,
I've heard that many times.
and I can see the sensible point behind that we really do want qualified people in the roles. But there's also a problem, I think, behind that we have to ask the next question: why aren't enough qualified people applying? So there's the application bit, or why aren't there enough qualified people? So two quite different, or potentially quite different questions, and think about what we can do about that. And I think a lot of work is being done on that. So if I give you a very old example, in one of the institutions I worked in, one of the faculties, it wasn't law was actually doing quite well on this, but one of the faculties that was typically male dominated had a habit of having all male shortlists for new jobs. And instead of going about the process by saying, you've got to appoint a woman, the practice that was adopted was, you've got to have a woman on your shortlist unless you can explain why that's not possible. So it's comply or explain, isn't it? Which meant that typically with comply or explain, people comply because it's too hard to explain. I mean, you know, there is no woman in this discipline that could possibly be good enough for our university is quite a hard proposition to defend. And as soon as you start getting women on shortlists, you start getting women promoted. So one of them is making sure women apply by not saying we're going to appoint you, but by actively encouraging the applications. And then there's the, why aren't there so many qualified women? Now, I think there are a lot of reasons for that. One of them is role models, you know, that there aren't enough people about so that you can say, oh, she's done that, I could do that, or, you know, this person from this background has done that, so I could do that. And that happens not just with men and women, you know, where this must now be a couple of years ago, but the Vice Chancellor in Cambridge said to me, you know how many Black African professors we have in the university? And I said, well, I know one. And at that stage, there was only one. Now, if you look then at, you know, what people think that they can achieve, there are quite a lot of people lower down. So, you know, the pipeline is building up, and no doubt now there are, you know, more than one person in that group. But the role model, you know, you have to be very good at making sure that there are role models that are visible, that encourage people to think that this is an option for them. And so I would think we should do a lot more about making sure that the applications are made. So really actively doing that. And I quite like the rules that you can't have a short list without having a woman. And now we're doing more on ethnic diversity and that kind of thing. It's sometimes quite hard. I'm sorry, we can't find someone who's of this particular ethnic background to put on the short list. And that tells you something about the other side of it, which is let's look after this pipeline a bit more proactively than we do. But I'm less in favor, as I no doubt indicated at the beginning, less in favor of saying we must now immediately have 50-50 of men and women, or, you know, this percentage that represents the population of people on the Supreme Court or wherever we're talking about, because I do hold to the view that, you know, if we're going to have a rule of law, then part of it is the credibility of the institutions. And if you're going to have governments, not governments, well, governments is also true, but if you're going to have companies that people have, where people have credibility in the management, then at one level there are other characteristics that all have to play into the weighting of who gets a role. That was a very long-winded answer. I am sorry. But
there's maybe another aspect. I attended the conference here on these issues of gender balance here in Tokyo, where they had invited a minister, a Danish minister of, I think, family or health, who was a lady in her 30s. She was like 33 years old with 3 children. And she said in the parliament of Denmark, they passed a rule that there's no voting for laws or no decision making after, I think, 4 p.m. Because in the Danish parliament, before this rule was passed, often the decisions were made at 1 in the morning. And, you know, there are long discussions, but even though this, in an ideal world, it wouldn't be like that. But the reality is that women often take care of the children. So they had to take, women ministers had to go to pick up the children at the kindergarten at 5. So they couldn't stay to pass an important law at 2 in the morning. So this is a more technical issues about how the job is organized. So
I agree.
So that addresses your point you made about the application, to how to get more applications, because
but also how to get the pipeline. Actually keeping people in. You know, the number of women lawyers who leave law firms before they hit the partnership level, they're doing remarkably well. In fact, there may well be more women than men when they, you know, at the first intake, but by the time they get to pre-partnership level, lots of women have dropped out, and some of that, not all of it, no doubt, but some of it is lifestyle stuff. And, you know, I used to think it was just lawyers, but one of our daughters worked in a very big architecture firm for a while, and I thought, this is just like a law firm. You know, there are all these people there working every hour God gives you.
Hello?
Kind of thing. Well, she got fed up. She said, you know, I actually have a relationship. She wasn't married at that stage. I have a relationship with someone, and, you know, I want to see them. So we sometimes make each individual work so hard that by the time they hit often they're 50s in law firms, you're almost, out. We've had enough of you. We've burnt you out and you can disappear. It seems a bit ridiculous, pay people marginally less, have a few more of them, and make it slightly more accessible to a larger and more varied cohort to keep on going, would be my view. But I don't see that coming anytime soon, to be perfectly honest. So, yeah.
I think we have taken an enormous amount of your time already. Maybe if you want to make some concluding statements, maybe?
I can make a very simple concluding statement. Thank you, Gerhard, for asking me, and thank you to all the rest of you for turning up. In some ways, we didn't go round the room, and I almost feel as though it's a room, getting everyone to have some input, but I did enjoy the way you made it feel more like a conversation. I liked that. So for me, it's been a lovely way to end the week in many ways. It's still Friday morning here, but it's nice to have a chat rather than just talk at people without getting so much reaction. So thank you for setting it up like this.
It was absolutely fantastic. Thank you so much for accepting and putting so much passion into this conversation here. And I hope very much, we have these meetings about once a month here in Tokyo, and normally when the viruses permit, we meet with dinner and drinks. And so maybe you can, have you been in Japan already or not?
I've never been to Japan, and everyone I know who's visited says that this is the place that I must go. And interestingly, I don't know if this is true, I'm doing it with the romantic eye of someone who's not been. It strikes me as the culture and the population that will be most different from anywhere else. And you might think, well, what about Beijing and Shanghai? But, I have been to those places, and, been to various places in India, etc. I still think Japan, I'm going to find more different than any of those cultures. So I shall come, and now I've got your name in my book, so yes, I shall be in touch.
Yeah, Japan is interesting. There are only 2 countries in Asia Pacific area which were never a colony. And one is Thailand and the other is Japan. So, and that's not a coincidence, I think, because it's not that the Portuguese and the Spanish and the British didn't try to make Japan a colony, but Japan is one of the few countries which had the strength to keep the invaders out. And so it's not a coincidence. And that, Japan was completely shut off for, or not completely, but almost for 200 years. Yes. So that's maybe what you mean by being so different. And one of the most beautiful places in Japan is actually Kyoto, where Professor Kinami is from. And if you come here, I'm sure Professor Kinami and others at Kyoto University will be delighted to see you in Kyoto and show you all the temples there. No, not all of them, but some of them.
Unfortunately, I'm retiring this March.
Really?
It makes no difference. You'll have even more free time.
Oh, that's right. I can be your tour guide.
Exactly. Well,
thank you, Sarah.
That would be my pleasure. And thank you all very much, especially Gerhard. Thank you for organizing.
Thank you so much for your
I shall say goodbye and let you do your wrap up with your group. And I'm sorry for you that you're not all going to dinner, but I'm especially sorry for me that I'm not there coming to dinner. But thank you all very much. And
thank you so much.